All right, everybody, we're going to go ahead and get started. So welcome to the Top 5 series for August in here. For those of you that are joining us in the classroom, I'm going to give you a quick heads up. We actually have people watching online. We simulcast this out. So we have 23 chambers that usually have this link and invite their own chamber members in to watch, as well as we open registration to watch via simulcast from your desk. So if you have a question, which we will save until the end, make sure you raise your hand and have the mic. Otherwise, the people on the simulcast cannot hear you. It looks like we're miming up here. So just keep that in mind. And Jackie will cue us in when she's ready for questions at the end. So today we are happy to have Whitfield and Eddy and Jaki Samuelson here to donate her time today. She is a local advisor. She's an advisor local, regional, national, and international organizations, providing employer-client counseling, consultation, negotiation, and completion of severance agreements for highly compensated executives. She also works with both firms and executives in severing business relationships. In the Chambers USA, a client commented that she gives clients the viable option that one can take and the ramifications of each of those options. Samuelson is a regular speaker, which is why we're glad she's donating her time here today, on employment topics, including drug and alcohol testing, issues for employers, and employer issues regarding workplace violence. The trends of ABC employment law, which she's going to run through with us today, and risk avoidance programs for business. So please help me welcome Jaki Samuelson.
Thank you all. Thanks to the partnership for giving me an opportunity to talk to you today. I really appreciate the fact that all of you are here in the room, as well as the people who are on the internet watching us. So we're going to go through these top 5 things to know about employment law. We're going to focus on regulatory issues and what to do if you have a complaint. Just to start, help me understand who all's in the room. I didn't make it around to talk to quite everybody. Do we have any employers with less than 4 people? Okay, you folks are lucky because some of the things we're talking about won't apply to you, and I'm going to try to point that out as we go. I know we have someone with over 200. Anybody else in that large employer range? So we have the full gamut. We're going to start with just an overview of the top 5 things I want y'all to know. And they're kind of cutesy, but I'll tell you what they really mean. So the first thing is know your ABCs. And that's really the core of what we're going to talk about today, because it is a section that's going to focus you on the myriad, literally, of laws, state and federal, that apply to employers. And most of them you're going to know about, but most people leave this presentation saying, gee, I didn't know about that one. We're going to talk also about an ounce of prevention saves a pound of time and money. And that's a focus on what some best practices are to try to avoid getting in trouble under any of the laws in number 1. Then we're going to talk about heeding the squeaky wheel. And that's going to be a little bit of discussion about how to deal with complaints, internal complaints primarily, by your employees or situations that you as an employer have observed and need to correct. 4th thing we're going to talk about is don't be caught napping. If you snooze, you lose. Because another thing that employers need to know about employment law is there are certain statutes where regulators can just show up at your door. And if you aren't prepared and don't know what to do, it's very easy to give them information, be involved in a situation that you weren't prepared for and make mistakes. So we'll talk a little bit about what you do if you have that regulator show up. And then finally, we're going to talk a little bit about the fact that we live in uncertain times. A lot of things, and those of you who are in the HR field know all the things you ramped up to be doing, especially as it relates to overtime, overnight changed back to the way they were. And that's really where we sit with a lot of issues right now, but we can define for you what the priorities of some regulatory agencies are, and what we know about living in uncertain times really goes right back to number 1. You're safest by knowing what the ABCs are, what your current responsibilities are, and stick with that And it's maybe even better not to try to predict right now because we have no idea what's going to happen. So, knowing your ABCs, this is just going to be an overview. We're going to race through the ones I know you know about pretty quickly, but just raising awareness. And if you have questions about any particular ones at the end when we have an opportunity, I'm happy to go into more detail. So, we're primarily talking about statutes. Employment law is very heavily statute related and regulation related. So the federal laws on employment discrimination, I think everybody knows about. There are state law counterparts to that. There's Title VII, which prohibits discrimination and harassment based on race, color, religion, national origin, gender, and pregnancy. In Iowa, the Iowa Civil Rights Act covers all of those things, plus some others that we're going to talk about later, plus gender identity and gender identification, or gender preference, which is not covered by the federal law, but is covered here in Iowa. Those of you with less than 4 employees, neither one of those statutes applies to you. Good practice may be, however, to follow it. Sexual harassment is one of the bigger things that people worry about, and that's actually an enforcement priority now for the EEOC. They have priorities every few years that they publish. There are 2 kinds. One is quid pro quo. That's when the supervisor asks somebody for some sort of sexual favor in exchange for some job benefit or detriment. Those are probably the easiest cases for an employee who has been damaged to get some compensation for. If they can prove that happened, that's a pretty bad thing. A hostile work environment is another kind of harassment case. That one's much more difficult. Employees have to prove that the overall ambiance of the workplace was hostile. It's not 1 or 2 isolated incidents. It's an ongoing bad environment. Now, that doesn't mean that as employers you should tolerate any kind of sexually harassing conduct, bad comments or anything like that, displays of things that are inappropriate in your workplace. But be aware, if it comes down to liabilities, that it has to be pretty bad before it gets raised to the level of hostile work environment. This statute, as all of these statutes that prohibit discrimination of any kind, and many of the other statutes prohibits retaliation. So if somebody makes a complaint, you need to be very careful not to in any way retaliate against them because they have made the complaint. And it's a particularly tricky situation where there are ongoing performance issues or behavioral issues, which is not at all unusual in these cases, and you want to take action against them, but they've just made a complaint. And that's the time you want to contact some assistance and talk through it with your lawyer or whoever you consult with about human resources and personnel issues, because even if you didn't have any liability for underlying harassment or discrimination, if you took adverse action against an employee after they complained, that's a whole new piece of exposure. So you want to avoid that. There are some affirmative defenses. We're going to talk about those when we get to the part about investigating complaints. But the important thing to know about affirmative defenses for employers is have a policy that prohibits discrimination and harassment on all the various bases we're going to talk about. It needs to include some sort of complaint procedure so the employee knows who to go to and tell about the problem. And there has to be some form of investigation when you receive a complaint, and you need to make sure it says do not retaliate. If you have that policy, you have the basis, as long as you follow it, for the affirmative defense in certain circumstances. Other statutes, the Age Discrimination and Employment Act, that protects people over 40 from discrimination and retaliation if they complain. In Iowa, interestingly, there can also be discrimination based on age, whatever your age is, so there can be discrimination against younger employees as well. And there have actually been some cases out there where an 18-year-old said, I was discriminated against because they wouldn't consider my application because I was too young and there's no reason I couldn't have done this job. So you need to think about it if you have an age limit for who you're going to hire, why that's important for the job that is involved. ADA and the ADAAA, which is the amendment to it, protects against discrimination based on disability. And I'm not going to spend a lot of time talking about what's a disability. Just assume if it's something that is a medical condition, whether or not it can be corrected and it's ongoing for the person, it's probably a disability now. It didn't used to be that way, but it is now. That's a statute that requires reasonable accommodations. And that means if the employee comes to you and says, I have this medical condition and I need help, I need something that will help me do my job. I can do my job just fine if I just have this thing. And it could be something really easy, like a screen to make it a magnifier for their screen so they can see better. It could be something difficult, and I really had this happen with a client, had to buy a taxi ride for someone every single day to get to work for a period of time, because that was the accommodation they needed during a time they couldn't drive, and for whatever reason, no other ride was available. It can be a whole range of things. The important thing for you to know, and I saw an oh my God over there, the important thing for you to know is it's an interactive process. If an employee asks for accommodation, you say, okay, what do you need? And then you can suggest other things, and you have to determine whether you can provide it without an undue burden. Obviously, the taxi rider, the employer had a lot of resources. And so the governmental entity involved said, you can afford this, you do it. A small employer, that would not be a reasonable accommodation. So that's one, again, if you get a request for an accommodation from an employee, and again, you folks with under 4 people, not covered. But if you get a request for a reasonable accommodation, you probably want to get a little help and advice on sorting through that, because those can be sticky. And there are prohibitions in that act for requesting medical information from employees, and obviously we know we don't distribute medical information outside the workplace either. So those are just little fun things you can look at in your spare time. So I mentioned the state laws. Some cities have municipal ordinances as well that provide the same protections. USERRA, that covers military veterans, and military veterans have all kinds of rights if they leave to, if they're deployed, to go on active duty and then they come back. They get to go back not just to the same position they held, but the position that all their peers who may have been moved up through the ranks now hold. They get a bump in pay if their peers when they left have gotten a bump in pay. And the important thing that a lot of people don't know is for the first year they're back, if they're gone long enough, they have job protection and they aren't at-will employees. They can only be terminated for cause for that first year after they're back after a long deployment. Again, this is one that you need to have information about. If you have a military person on staff and they're going to be deployed, know what their rights are, because they're a little tricky. Family Medical Leave Act, this applies to employers over 50, so some of you, but not all of you in the room. And the 50 have to be in a 75-mile radius. Employees have to work a certain number of hours, 1,250, and that's not in the past month. Oops, that's in the past 12 months, 12 in the past year. We'll have to fix that one going forward. And these employees can have, if they qualify, can have 12 weeks of leave for a serious medical condition of their own, to care for a child, spouse, or parent's serious medical condition, or for the birth or adoption of a child. And that's both men and women have that right. And there's also a section of it that gives some additional rights to members of military family members to help them if they have a sudden deployment, just get their life together and cover their business and personal needs, and also for caregiving if they come back for an injury. But before I leave the FMLA, that's another one that has lots and lots and lots of traps for the unwary. There are notices that have to be given. You have a right to get medical information, but you have to follow all the rules and the deadlines. Be educated about that one. Get help if you need it. The Iowa Civil Rights Act provides maternity leave for smaller employees. And again, if you're under 4, you're okay. But 8 weeks doesn't have to be paid, but you do have to treat it the same way that you would treat any other disability. So if you pay people on other types of disability leave, you have to provide 8 weeks of paid disability leave in connection with childbirth. That does not apply equally to men and women, just women. National Labor Relations Act, most people equate with unions. I assume, does anyone have a union here? No unions. And that's really what it primarily deals with, but there are some things to know. Obviously, be aware if you might have some organizing efforts in your workplace. You should get some help and work with somebody who is experienced in labor law. But there are things that apply to employers who are not union shops as well. The one that's probably the most important is you have to be careful about prohibiting employees from communicating about their work conditions. A lot of employers have things right in their handbook that says you can't talk to other employees about your salary. Well, guess what? That violates the National Labor Relations Act. So you should not be restrictive about what they talk about if it relates to work conditions, and that includes in some cases what they talk about on social media. So as you're regulating employee speech, work conditions is not something that should be regulated. Fair Labor Standards Act, this is the one we really all know about, minimum wage, maximum hours, overtime for more than 40 hours a week. This is the one that caused everybody, a lot of people in this room probably, to spend a lot of time and money getting ready for the new exempt employee definition that all of a sudden went away, first with an injunction and now with just interminable hold because we have a new administration. An important thing to know is if your employee says, I don't need overtime, I just want comp time, I'll take it off later. You can't do that if you're a private employer. If you're a governmental employer, Jeff can do it because he works for a governmental entity. But as a private employer, unless they take that comp time during the same week, even if they volunteer and say, I want comp time, you can't and shouldn't let them do it unless they're willing to do it right away, because you owe them overtime. The Worker Adjustment and Retraining Notification Act, we hope none of you in this room will ever have to know about. That's the one that requires a warning. According to the state statute, if you have 25 employees, federal 50 employees who are going to be laid off all at once. And the warning is not just to the employees, but also, to governmental entities. Workers' comp and unemployment, I'm pretty sure we all know about that one. I'm going to skip over quickly. Iowa Code 91A, the Wage Payment Collection Act, is just generally how you pay, when you pay, that sort of thing. But also important to know that you cannot deduct things from people's wages unless you have a written authorization from them and it is something that you have advanced to them that is for their benefit in some way. So if you've advanced them a uniform and they don't return it and you want to deduct from their pay, you need an authorization in writing. COBRA, Iowa Code 509B, continuation of health insurance. ERISA, that's the benefit statute. The Affordable Care Act, we all know what that is, but we don't know what it does anymore. I would hope you all know about Homeland Security Act and getting mandatory identification. OSHA and IOSHA, that protects safety in your workplace. We'll talk more about these folks when we get to the investigation piece, because they're some of the people that may show up at your door. And that's just a little OSHA thing. Drug and alcohol testing, does anybody do it? Okay, we'll skip over it pretty quickly because it only impacts one person, but Iowa's law is about the strictest in the country. and you have to follow it strictly. Very few deviations are allowed. Just make sure you know what it is and give it thought before you adopt a drug testing policy if you are thinking about it, and make sure you comply. And by the way, I had a client, new client, they don't do this anymore, that used a fishbowl on their counter for random drug testing. They pulled a name out every week. That's not okay. We won't dwell on this one because we don't have time, but there's some anomaly in Iowa law. Iowa law actually has a blacklisting law that restricts people basically with respect to any effort to prevent an employee from getting another job after they've been discharged, except by furnishing in writing a truthful statement as to the cause of the person's discharge. And then it has, and it's criminal as well as civil. And then there's an Employee Reference Protection Act that says employers are immune from liability if they get a request from a prospective employer and they provide work-related information unless they act unreasonably. So, a trap for the unwary. Blacklisting is very rarely used, but it is out there, and occasionally some people will allege that that happened. Iowa Code 91B requires employers to give employees access and copies, if requested, of their personnel file. It does not require former employees be given those things. A lot of employers do it if they get a request, but you don't have to. Uniform Trade Secrets Act, there's a federal one as well as the state one now that takes care of your proprietary information and is really a pretty potent tool if somebody leaves with any of your confidential information. Finally, one that's good for employers. And be aware, if you do things in other states, that the laws vary drastically from state to state. So if you have people elsewhere, you need to know what the laws are in other places as well. So common law claims, there's at-will employment, but there are exceptions for public policy violations and whistleblowing. Defamation, don't say bad things about your employees in public, and there are even concerns if you do what we call the walk of shame, which is after someone's been terminated, they have to walk by all their co-employees to leave or get their stuff. Don't do that. People sue about it. Be sure you wait till the end of the day or some private time, make arrangements. Invasion of privacy, this is a hot topic. It is so easy to know when employees are off doing things on their own time, supposedly, but really on your time, like if they call in sick and say they are can't get out of bed and you see them on social media on a bike ride. In Iowa, we're pretty good about allowing some level of that, but that's an increasingly dangerous thing for employers to do, is take action based on what people did that they found out on social media. There's very few contract claims in Iowa. Only if there's a written contract. Be sure your handbook says it's not one. And that gets us to, well, okay, we have this long list of things that can go wrong and that we can do wrong. What do we do to avoid those? And I know that this program, the partnership series, has had and is going to have more information about hiring and making sure you don't make mistakes at that end. So we'll just, the advertising and application process, you're probably going to have an opportunity to hear more about, but the real touchstone for all of this stuff, every step of the process, is be consistent. Use standardized questions, standardized applications, treat everybody the same, put the same documents in front of them. Document what you do, and just be aware of the ABCs and be consistent from person to person to person in how you treat people, so you can avoid being alleged to have treated somebody differently because of one of those protected classifications, because they made an OSHA complaint, because they did something that would give their rise to a cause of action. Keep your applications for 1 year. The EEOC said you have to. So at interviews, uniform questions. Don't ask questions pertaining to any protected classification. pregnancy, child care arrangements. I was hired a long time ago. They asked what church I went to, what I was going to do with my kids when I had them. They probably hit every prohibited category. That's a long time ago and nothing happened. You do that today, you'll be in trouble. With respect to disabilities, you can tell the person what the job is, ask if they'd be capable of performing the full range of duties, either with or without accommodation. If they say they need an accommodation, then you have that interactive discussion we talked about. So, but don't just toss them out and say, no, we can't hire you if they say, yes, I need an accommodation. So you've interviewed, you're down to selecting who you're going to hire. Do you have job descriptions? If you don't, you probably should. Use those to evaluate their qualifications, because you want to do your very best to hire the person who is best qualified for the position. And you want to be able to explain why you chose that person. You know, my gut tells me this person's the best, probably not a good explanation. And it's particularly important when you're comparing a protected class member, which is all those people on the list we talked about at the very beginning, is about the only people not on that list are males under 40, except in Iowa where there's really no age restriction. So you need to be able to have a good, rational explanation for the decision you make, and it has to be based as much as possible on objective factors. Now, everybody has subjective things that they feel are important. And there is importance to, I have a good feeling about this person. I think they would be good with people. Things that you can't measure. But be able to explain why, if at all possible. Discipline, there's actually 3 things, but these 2 can be consistent from person to person. Please be confidential. Don't share with others the disciplinary action that you took against their peers. And please, please, please document it, because the disciplinary actions are the things that start getting you into the risk area for claims once you start down a disciplinary path. And if you come to me after you have the claim and you say, oh, we had really good reasons for this, and here's what they were, and now I'm going to say, well, where's your documentation? And if you don't have any, then it's going to be your word against the employee who's complaining's word, and that's not where you want to be. So it's great to have a form, a disciplinary form. Use it, keep notes, keep track of it. Use some kind of progressive discipline unless it's a particularly egregious offense that needs immediate attention. And don't prepare the documentation 3 months later, or especially don't prepare it after you got a complaint. It needs to be reasonably contemporaneous. It doesn't have to be exactly right then, but keep track of it, keep it in your personnel file. So this is the introduction to performance appraisals. And a lot of workplaces, especially historically, did it just that way. But now most everybody does performance appraisals. In one way or another, whether you do it on a form or you do it with a checklist or whether you just have informal discussions, employers should have discussions of some kind with employees about their performance. You should value or evaluate everybody's performance consistently. So if your expectations of John are this, for Jane they should be the same thing if they're doing the same job. Unless there are differences in their job that justify difference in how you evaluate it. You should document it, once again, some kind of documentation, even if you have an informal discussion, scribble a note. And again, keep it confidential. Don't be sharing with other employees unless they have a need to know, and that's generally your management. So it gets to the end and things haven't gone well and you followed all your disciplinary steps and you are considering whether you're going to terminate somebody. The first thing you ask is, okay, has anyone else ever done this before? And if the answer is yes, then the question is, well, what did we do with them? And if you didn't terminate them, you ought to think hard about, well, then why do we want to terminate this employee who's engaged in the same conduct. And gee, we just like them, the other guy better is probably not a good answer. You want to be sure that your reasons are documented in the personnel file in some fashion. I will be honest with you, I'm run about 75-25 on whether I get documentation from my clients when they want to terminate someone. That's 25%, there's just nothing. And that doesn't always mean you can't. But it's much, much better if you have the documentation. Have more than one person in the room when you tell the person they're going to be terminated. You want to have a second set of ears and eyes on it. Please be sure that all wages are properly and timely paid. We go back to that Iowa Code 91A. It tells you can pay them out at the next payday. You don't have to hand them the check on the spot. You have to pay them their vacation pay unless your policy specifically says that you don't pay it when they're terminated. And that gets paid out at the next payday as well. An amazing number of claims come out of and this whole "and I didn't get all my wages" thing. And so just do it right to begin with, and you can avoid problems with that person going forward. If you get a reference check, we looked at that statute a while ago that said, well, as long as you tell the truth, if somebody asks you, it's all fine, or act unreasonably. But then remember, we had the one before that that talks about blacklisting. And really the safest thing is to just kind of do name, rank, and serial number. The years of employment, you can tell them what their salary was, what their job was. And then most employers will say, well, would you hire them again? And generally speaking, it's okay to say yes or no, but it's kind of a trail of tears. And a lot of employers choose to say, we just don't provide that information. But be consistent in the way you do it. So, you've used all your best practices, you know the law, and notwithstanding that, you get an internal complaint. So you should always investigate. But what investigate means can mean different things and with different types of complaints. Some things it's just people being growly about the person who sits next to them always being late. Well, that's something that's a pretty easy investigation. You go and talk to the people involved and maybe the people who sit next to them. You see if the observation that this person's always late is true, or maybe you have independent information. You walk by the desk. And that's probably all the investigation you need before deciding if you're going to do something about it. If it is a complaint of discrimination or harassment, remember you're supposed to have a policy for that, and it's going to have a complaint procedure. And that is one where you do want to have a relatively formal complaint, because that procedure can help save you from liability if you follow it. And obviously you may want to just, if you see something that needs investigating, you just want to investigate it. The in-between one, if you observe or know there's a violation of some law, regulation, or policy other than discrimination or harassment-based kinds of statutes, those things, just you have to take a look at it based on what the nature of the complaint is. So we talked about the affirmative defense. We aren't going to go through all of the technical legal things about when it works to have an affirmative defense or not, but it is in your materials, and we encourage you to look at it and ask questions if you have any. You have cards available somewhere. You can call me afterwards and say, I was at this seminar, and I want to ask a question about that, and I'm happy to answer it. So here's some really quick tips on a good investigation. Do it promptly. Sometimes it takes a few days, especially if it's a formal investigation, to get your act together and get it done. But don't let it linger. Don't wait weeks. Do it within days if at all possible. Whoever is investigating, and we're talking now about the more formal investigations, needs to be independent. That means it's not the person that the complaint was about. It's not their good friend. It can be your HR director. It can be somebody in management. It can be a board of directors member. Some cases you want to have an attorney or an outside person investigate. You will probably know those when you see them, because it really has a lot to do with the seriousness of the complaint and the likelihood that that person is going to file a legal claim against you. Be sure you give your investigator all the relevant information. And they may not know what to ask for. You know more about what you have and what is available than they do. A good investigator is going to be very comprehensive in what they ask for, but try to be proactive and get the information to them. While an investigation is ongoing, a woman complains about her boss harassing her, for example. You need to figure out how to deal with that situation while the investigation is ongoing. And a lot of times that can be handled by just separating them in the workplace so they aren't interacting day to day. You want to, however you do it, you want to be very careful not to make your remedy for that problem, keeping them separated, feel like punishment to the person who complained. A lot of employers' first instinct is to just have them stay home until it's resolved in some way. Well, that's a bad idea, because they just feel like they got suspended, even if they're being paid, while the person they complained about is going their merry way at work. So think through how you can make it a better situation before you decide what to do. Talk to the complainant first, find out what it is they're really complaining about, what the scope is. Talk to whoever allegedly committed the bad conduct. Talk to any witnesses. Sometimes there are some, sometimes there are not. Look at the documents. See if you've got a history of complaints about whoever the alleged discriminator or harasser is. We talked about not making the complainant the target. That doesn't just mean keeping them in the workplace and as part of the regular employment day-to-day activities, but also don't start asking everybody in a focused way about whether that person has a history of doing things that invite this conduct, because that starts to make your investigation look like you are skewing it in favor of the person who has been accused of bad conduct. You have to hit a balance. You want to know if they do have a history, but you have to not target. This is where having a good independent investigator who has some experience can help you a lot, because they know how to answer those questions. But you can do it too if you're doing it internally. If you think about it, if you get some advice. You can't promise people complete confidentiality when you sit down and talk to those witnesses. You need to tell them, or the complainant. A lot of times the complainant says, you can't tell anybody. I don't want you to tell anybody. And you can't investigate if you don't. You can't really do anything about it. And there are some situations where people are so adamant once they make the complaint that they don't want anyone to know, that you have to say, well, that's fine, but we really aren't going to be able to investigate this. We will keep our eye out, and if this happens again, please come back to us. That is rare. That rarely happens, because usually when you explain to them that the only way you can get to the bottom of the situation is by conducting an investigation, they say, and you say, we will treat it as confidentially as we possibly can. That's usually satisfactory to the people involved. But if not, and they just are adamant, no, I don't want to go forward with my complaint, then the burden really gets to be on you to keep your eyes out going forward and make sure you're watching for similar kinds of conduct that you observe as the employer, without the benefit of that person's complaint to be a catalyst for a change. The last thing in the world you want to do is force the person, and this is really about any kind of complaint you get, the person who complained and the person they complained about to sit in the room and hash it out. That is a very, very, very common practice amongst employers that I've worked with through 30-some years. Not a good idea. It generally does not end the problem at the end of the day, and it generally causes some hard feelings about you as an employer. And finally, and most importantly on investigations, you want to avoid retaliation against the person who complained. On rare occasions, an investigation will demonstrate that the person who complained has performance issues or some other kind of bad conduct issues, and you need to do something about it. That's a very rare circumstance. Usually, you just appreciate the complaint, whether it's founded or not, and you move on and tell both of the people, the alleged victim and the alleged harasser or discriminator, that no retaliation will be tolerated of one against the other. So after you get done, report, tell the complainant what you found, address any problems you found, and again, remind everybody not to retaliate. Quickly, we'll talk about what happens when somebody comes to the door who is a regulatory body. It does happen. OSHA does that. The Department of Labor does that. Usually, you get a letter ahead of time, and the letter tells you they want a bunch of documents and they'll be on your doorstep in a week. And that gives you an opportunity to get your attorney involved, to gather your documents, to figure out what this is all about to the best of your ability, and to be prepared. That one's fairly easy, and I do highly recommend, if you're going to have an OSHA investigator, a DOL investigator, any governmental body come to your workplace, that you seek legal counsel, because they will come and they'll be your best buddy. They'll be just friendly and nice. Some of them are cranky, but most of them are very good at being cordial. And it's easy to just start talking to them and giving them stuff, and some of the stuff you probably didn't have to tell them or give them, and it can be used against you. So don't just take for granted. Remember, they work for a governmental agency that's enforcing a law, and they work for that governmental entity probably because they have some bent to do that enforcement, and they're not your friend. If they just show up at the door, you can say, come on in, have a seat here. We're going to go contact our attorney. And if you can get a hold of your attorney or someone to give you legal advice, do that. And usually you can negotiate with them to stand down, tell you what they need, what you want, the same thing they'd tell you in the letter if they didn't just show up, and then you can work on pulling that together in a thoughtful and appropriate way with some counsel. Occasionally you have a really bad situation. You had an accident at your workplace, a really bad accident at your workplace, and then they're not going to give you that opportunity. So in that case, you be polite, you give them what you can, and you ask them what else they need, and ask them for some time to pull it together. And at the same time, there's somebody in the other room calling your lawyer. And because what happens at those seemingly regulatory and relatively benign sometimes investigations can end up with liabilities for past wages, for fines from an OSHA standpoint, and sometimes you have defenses against those things, but if you really don't know what those are going into it, it's easy to let them slide by. So finally, last topic. We live in uncertain times. What to expect in 1718, really up in the air. Here are some of the things that we don't know what's going to happen. The fiduciary rule, which applies primarily to financial institutions and advisors, the Affordable Care Act, overtime, joint employee issues, just regulatory enforcement in general, because while Congress is getting nothing done, in the background, the regulators, the Department of Labor primarily, and they administer a lot of the stuff we just talked about, they're changing regulations or putting them on hold or doing things totally differently. And we all I have to watch every day. We may or may not know what's different today than it was yesterday. So we do know what they have announced as priorities in the Department of Labor agencies. So transgender pregnancy, pay equity, misclassification of employees as contractors, discrimination particularly against Muslims and Sikhs. I think that one's probably by the wayside at this point. And systemic harassment. And remember too, a lot of the people on the ground level who are doing stuff, your Department of Labor people, your civil rights EEOC people, are still old administration appointees. It's trickling down from the top that we're not so interested in any of this stuff, but the people on the ground still are. Other things, overtime violations in certain industries, hotel, restaurant, retail. I know we have at least some retail type industries in the room. Nursing mothers and lactation rooms. Do y'all know you have to have lactation rooms? I hope so. Even if you're under 50 employees, unless it would be unreasonable for you to provide a private, protected space for a person, you have to have a lactation room, and we're not going to have time to go into detail, but in your materials, there is a detailed description of what that has to involve. Franchising, subcontracting, independent contractors, and class action waivers, which is on the way to the Supreme Court. We all know there was a bunch of Iowa legislation, and I just want to point out to you your bonus slides. I knew I wouldn't get to them, but here they are, just subject matter-wise. These are things that I've been running into a lot and thought you might want to know about. So lactation rooms is one of them. Employee mental health issues, probably the most challenging thing that an employer can deal with, because you're empathetic, you want to help, you want to do the right thing, but it can be a nightmare in your workplace, and there are all sorts of legal protections available for folks. So I commend the slides to you for some information. And finally, background checks. Who does them? Take a look and make sure you use the information properly. So I have gotten to the point where we are going to take a little break from me just rattling on and on and on, and give you at least a little bit of an opportunity to grab the microphone and ask a question.
All right, who has questions?
We have our anti-discrimination statement in policy and on our application and in various places on our website, and between the national list and the state list and maybe even local lists, it's getting quite lengthy. And I'm wondering, is there anything wrong with just replacing that long list with something as simple as we don't discriminate on any protected characteristic or any characteristic protected by local, state, or federal law?
And the question was, in case, and we weren't sure everyone would be able to hear it, not just in this room, but on the web. Is it all right to boil down that anti-discrimination statement, because there are so many moving parts to it, so many different statutes, into we don't discriminate? I guess my answer to that would be that on something like your application, maybe you could boil it down. On your web page, in your handbook, I would want you to list each and every one of the statutes that you don't discriminate based on any of those protected classifications. And honestly, I would prefer to see it be listed out, even if it's long and takes up extra space, in all of them. Because I think of it in this way. Someday that might have an exhibit sticker on it. And if somebody says I was discriminated against based on my gender preference, I'd want to be able to hold up that exhibit and have it listed right there. Much more impactful, in my view. Mm-hmm.
It's actually on the screen right now. Can you go into a little bit of detail on the ban the box efforts and where you see that going? And if there are any I guess for nonprofits or for organizations that work with children, if that would have any effect or any difference if an actual statute or if something took effect.
The question was whether the ban the box efforts as it relates to background checks, and that basically, the ban the box effort is employers should not ask about criminal history or arrest records. And so let's start with Iowa. At this point, not much traction for ban the box here. And to the extent any cities might have thought that they would depart from the statewide rule, I think that the Iowa legislature pretty much kiboshed that in its last session. So we're all consistent, fairly state and federal. Nationally, there are a number of localities in particular that prohibit just asking routinely everybody about criminal history, but I don't know of any location that doesn't allow you to ask if you're working with youth, if you're working with the elderly, if there is some good, solid reason to ask. But in the ban the box states, you need to have a very tailored, narrow inquiry that's going to focus on what is important to the evaluation and safety of your population. And anything that's really old, even if you have criminal background information, you've asked and you got it, if it's really old, if it's unrelated, even without the ban the box, it's not the wisest thing to rely on that to make a decision.
Other questions? You guys learned a lot today. You kind of look fried.
Pretty easy
I
duty.
grab my sheet here real quick. Okay, well, a couple things I wanted to mention. Let's thank Jackie for being here today with us and donating her time. And I'm sure she'll hang around for a few minutes too if you have other
Absolutely.
questions you just didn't want to raise your hand and ask. A couple things I want to mention that are coming up for more further entrepreneurial events that we have coming. First, Fridays is an event that we host with the Women's Business Center. We'll actually be interviewing Trisha with Trixie's Salon. She now has 3 salons up and going. It will be here on September 1st. Our next Top 5 series, which I left flyers for all of you, is coming up on September 27th. It will the topic will involve accounting. And then what I do want to mention is the month after that will be all on hiring employees. It's also taught by Davis Brown, which is why I asked her to kind of stay really high level on hiring employees today. So that will be an entire hour of information on that. And then the big one I wanted to mention is announcing today is our Small Business Success Summit. So the registration is open, but the major announcement will go out today. We only have 400 seats to attend this. The cost to attend is $79. There's 3 keynotes involving Google, Chad Willett, who's a former actor, and Dr. Senda Kamphoff, who will come in. We have 18 breakout sessions that day, depending on what issues you need to get for your business, sort of like our top 5. And then we have 28 resource tables that will be there to help you with your small business. So registration is open. It's November 10th. It's from 8 a.m. to 6 p.m. It's a Friday. We're hoping you register quickly because we believe all the seats will be sold out, and that is live. So last thing I want to mention is the surveys on your table. If you can fill those out, it helps us make the next session better. So please complete those and leave those, and I will leave you guys to get on with a nice day. Thanks for coming today.
Thank you all.